Welcome to today's recording, which is looking at the Mental Capacity Act and risk. This training session is based on the relatively recently published capacity guide and the section of that guide called "The Situation Seems Risky to Me." The slides will be made available to you after accessing the session, and all of the resources at the end you will see are in a light blue colour and are underlined, and these are working hyperlinks, so when you access the presentation, you will not have to go away and hunt for any of the resources or references. You'll be able to access these after the training session. So this session will be focusing on the Mental Capacity Act and risk. In terms of the outline of the session, I want to give a little bit of context at the beginning. So we'll start off with learning from tragedies, but also academic research in this field. We'll then look at risk and the principles of the Mental Capacity Act and perhaps how the principles of the Mental Capacity Act can be misinterpreted in practice. Then we'll start to look at, well, should we be proceeding in these situations? And I'll finish with a concluding case scenario. So starting off with learning from tragedies. One of the cases that always really jumped out to me was the case of Robert Crane. Robert died in a fire at his flat just 4 days after social services closed his referral. He had refused a community care assessment. Social worker had deemed his hoarding a lifestyle choice. I personally would say that this is one of the most unhelpful phrases that could be used in both health and social care. It begins to immediately appear that we are ignoring what might be an incredibly vulnerable individual, and that he had the mental capacity to make this decision despite him having a history of mental illness. An inquest found Robert's death was accidental. However, a serious case review identified missed opportunities to intervene and that services had failed to take Robert's mental health history into account when assessing his capacity. Now, in reality, and to give a bit more context, I would say this presentation is really focusing on those situations where a person is at considerable risk. I think the case of Robert perfectly articulates the potential challenges of engaging a person where there's a lot of risk, but that person is more than capable of engaging in a conversation with us. These are not likely to be cases where the question of competency or capacity are easy to unpick. They're likely, as perhaps the courts refer to it, likely to be more borderline. Mr. Crane was known to be articulate and resistant to receiving help. As a result, assumptions were made about his capacity based on verbal reassurances of his ability to cope. And one of the things I really want everybody who's listening to this talk to consider is where a person is giving lots of verbal reassurances of their ability to cope, is there any work done after to actually see whether that person is actually able to put those verbal reassurances into practice? So what can the research in this area tell us? A lot of the particularly good research in this area for me has often come from Michael Preston Shute and Susie Bray, really have focused in on this area of sort of self-neglect, safeguarding and the Mental Capacity Act. And these are some of the key points that they have picked up on in their research. Practitioners were too ready to close a case based on the belief that the person's decision making is a lifestyle choice. As I've already said, an incredibly unhelpful phrase to be using in practice. It does begin to feel like, sounds like professionals ignoring what's potentially an incredibly vulnerable individual. Individuals' decision-making capacity being assumed even when there was evidence of impaired decision-making capacity in other areas of life. Now, this is not a statement saying because a person lacks the capacity to manage their property and affairs that it automatically means that they lack the capacity to make a decision about their care, support, medical treatment, or make decisions about their hoarding or squalor or alcohol use. However, it could appear to be a negligent professional who completely dismisses that and perhaps doesn't explore whether or not the person is, in fact, able and willing to take on those risks. A failure to consider how a person's impairment or disturbance in the functioning of the mind or brain may affect their ability to both understand and probably most importance in a lot of these cases, and use the information when faced with the real world concrete situation, especially if they're refusing any support in the real world situation. And this links back very closely to that Robert Crane case. Lots of verbal reassurances, the ability to cope, the ability to understand, retain, and use or weigh that information in the conversation. Was any work done to see whether Robert could in fact use that information in the real world situation? A failure to assess the person's executive and performative capacity with too much focus placed on verbal reassurances from the person and their decisional in the moment decision-making abilities, without asking the person to demonstrate their coping ability, a process commonly referred to as the articulate demonstrate method. A person perhaps has not been drinking enough, ended up with a few urinary tract infections. You ask them the question, how would you make a cup of tea? And they tell you perfectly. Should perhaps we follow that up with, can you show me how you make a cup of tea? So not just focusing on the verbal reassurances, but the person's ability to actually use that information in the real world situation as well. A failure to complete robust assessments when decision-making capacity was unclear, borderline, or fluctuating. For any professional who is listening to this talk, who might be involved in multi-agency risk management meetings, one of the things that perhaps has struck me is professionals being sat around a table stating, well, the person has capacity. Two things that immediately come into my head when I hear that is, capacity for what? And once that's been clearly defined, if the person who is saying this person has capacity is still stating that, I would say, well, where's your evidence? Because if this is a situation that is later reviewed through a safeguarding adult review or through an inquest, is it likely to be the case that we might be asked, there are lots of statements that this person has capacity, but how was this conclusion actually reached? An absence of multi-agency working and or key agencies not being invited or failing to attend when invited. Many of these situations are going to involve decisions about care, residence, managing items and belongings in the context of hoarding, and is also likely to be in relation to medical treatment and care, management of diabetes, for example. But I think you can also think about person perhaps misusing drugs or alcohol, or what about accessing treatment services and rehabilitation services? So there might be multiple professionals supporting a person to make different decisions. And that's why it's so important that agencies do work collaboratively in these situations. So let's look at risk and the principles of the MCA. And to me, the two principles that jump out in terms of how they are misinterpreted in practice are principle one, a person must be assumed to have capacity unless it is established otherwise. And people often simplify this down to, the assumption of capacity. And principle three, a person is not to be treated as unable to make a decision merely because an unwise decision is made. I often hear people go, well, people have the right to make an unwise decision. Now, we could debate this in a pub with a couple of drinks, but that's not what the Act is actually saying. Nothing in Principle 3 says anything about the right to make unwise decisions. To me, it is making quite a simple legal point, which is you cannot jump from this decision is unwise and jump to, well, this person is unable to make that decision. To be honest, the Mental Capacity Act has no interest in what the outcome of the decision might be. It is interested in the person's ability to appreciate the reasonably foreseeable consequences of their actions. So risk and the principles of the MCA. The 39 Essex Chambers guidance on both capacity and best interests are absolutely fantastic, and they are linked to at the end of this presentation. But I think they perfectly articulate the dangers of misinterpreting Principle 1 of the Mental Capacity Act. If you have proper reason to think that the person may, lack capacity to take a relevant decision, especially if the consequences of what they are wanting to do is likely to lead to serious consequences for them, it would be simply inadequate. Remember, this is authored by legal professionals. For you to simply record, for instance, as there is a presumption of capacity, X decision was the person's choice. Indeed, the more serious the issue, the more one should document the risks that have been discussed with the person. And for me, this is the key part of this sentence, and why we considered that the person was able and willing to take those risks. They follow this up with a very helpful section of case law. The presumption of capacity is important. It ensures proper respect for personal autonomy by requiring any decision as to a lack of capacity to be based on evidence. Yet the section 1.2 of the Mental Capacity Act, presumption like any other, has logical limits. When there is good reason for cause for concern, where there is legitimate doubt as to capacity to make the relevant decision, the presumption of capacity cannot be used to avoid taking responsibility for assessing and determining that capacity. To do that would be fail to respect personal autonomy in a different way. Moving on to principle 3, the unwise decision. The person is not to be treated unable to make a decision merely because an unwise decision is made. But what does the code of practice tell us about this principle? Everybody has their own values, beliefs, preferences, and attitudes. Persons should not be assumed to lack the capacity to make a decision just because other people think their decision is unwise. This applies even if family members, friends, or healthcare or social care staff are unhappy with the decision. But there may be cause for concern if somebody repeatedly makes unwise decisions that puts them at significant risk of harm or exploitation, or makes a particular unwise decision that is obviously irrational or out of character. These things don't necessarily mean that a person lacks capacity, but there might be a need for further investigation, taking into account the person's past decisions and choices. Further investigation, well, pick that. Firstly, professional curiosity. Second, once you've followed the process of professional curiosity and had a conversation with the person, whatever conclusion you reach, whether it's the person's able to make their own decision, in fact they've agreed to support, or they are able to make their decision and they've refused it, or supported them to make a decision and actually I've reached a conclusion that they're not able to make this decision. Whatever the conclusion that you reach, surely you should record the investigation that you undertook and the conclusions that you reached. Now, this is a slide I use in all of my formal training sessions. Normally the title is, well, when should we conduct a capacity assessment? But I really think it fits in quite nicely into this section in relation to risk and the Mental Capacity Act. So I would argue probably 90% of the time we complete and undertake a capacity assessment because we have a reason to doubt the person's ability to make that specific decision. But what could be the other factors that would make us have those concerns? We must also be prepared to justify a decision not to carry out an assessment, where on its face there appeared to be a reason to consider that the person could not make that relevant decision. Whilst the presumption of capacity is a foundational principle, you should not hide behind it or avoid responsibility for a vulnerable individual. The more serious the issue, the more you should document the risks that you discussed with the person and the reasons why you felt that person was able and willing to take on those risks. No matter what the situation you're faced with, no matter what the conclusions, no matter what you take from this presentation, I would probably advise that that bottom bullet point is going to be absolutely essential to ensuring that your professional practice is defensible. So how should we proceed in practice? Again, this section in particular is taken from the excellent capacity guide, which I do reference to and will be linking you to at the end of the session. So how to proceed? If, for whatever reason, you need to reach a conclusion about the person's capacity, let's just unpick that. If for whatever reason, it might be that you doubt capacity. It might be that you don't doubt it, but other people have raised concerns, so you feel the need to explain how you've reached your conclusions. The third might be defensible professional practice. I believe this person is able and willing to take on those risks. So it's important that I'm able to record and show why I felt the person was able to understand that information, retain that information, use and weigh that information, and clearly communicate their own decision by any means. So if for whatever reason you need to reach a conclusion about the person's capacity, then it is important to be clear that none of the principles in the Act mean that you have to ignore risk. You do need to be careful not to jump from the fact that a person is making a risky decision to the conclusion that the person lacks the capacity to make it. And you cannot simply proceed to take decisions on a best interest basis because it seems like the right thing to do. But the courts have made clear that the European Convention on Human Rights imposes an obligation on public bodies not simply to accept at face value a person's decision which puts them at risk if there is proper reason to think that they might not have the capacity to make it. The European courts articulated it in the following case. The European Court of Human Rights found a breach of the Article 2 Right to Life ECHR operational duty, where the doctors took refusal of life-saving treatment where, despite the patient showing symptoms of a mental disorder, the doctors took those refusals at face value, without putting into question the patient's capacity to take rational decisions concerning their treatment. Notably, if the patient had agreed to undergo the treatment, the outcome might have been different. Have you discussed and explored the reasonably foreseeable consequences of that person's actions of refusing that care or refusing that treatment, which will typically be the case in these high-risk situations? Have we explored the person's reasoning for that refusal as well? There is sometimes a danger that we focus on the person's ability to understand and retain the information, but fail to explore how that person is using and weighing that relevant information as part of the decision-making process as well. So how then to make sure that we are in fact doing the right thing? Think about the person's capacity in this context. You should proceed on the basis that the more serious the consequences for the person of the decision, the more rigorous the steps that will be expected of the assessor before the determination is reached whether or not the person has capacity. In asking whether the person has capacity to make a decision which has particularly risky consequences for them, the information that they must be able to process includes those consequences, something which the Supreme Court has recently confirmed as well. So you can and should therefore test, and you must remember the mental capacity assessment is a legal test set out in law. We should therefore test whether the person can understand, retain, use and weigh the information that one course of action poses real risk to them, but another would potentially save their life, or otherwise potentially be much safer. Testing in this way is not the same as confusing the outcome of the decision with their ability to make it, which the courts have made clear you cannot do. Rather, it is an important safeguard to ensure that whatever decision is reached, it is reached on a proper and defensible, I would add, basis. So I want to finish with a concluding case scenario taken from a safeguarding adult review in Kirklees in relation to a person called Adult N. And at the beginning of the safeguarding adult review publication, there is a poem that had been written by Adult N. Lonely, resentful, and confused as a teen, you found me and took me to places I'd only dreamed. I found you in bottles, cans, and in pubs. Then later you showed me off licenses, bars, and clubs. For a while, we just met on weekends with our friends, but over the years, the drink changed with the trends. You started to change me and took over my life. You affected my work, my children, and my wife. From friend to an imposter, you started to be. I tried to ignore you and asked you to leave. You started to control me and take over my mind. The hope of you leaving was now left behind. I started to believe you wanted me dead. Still, I turned to you daily for relief in my head. I gave you my hand, which you took with a smile. You showed me dark places. We walked down the aisle. You left me to ponder the end of my life. I considered them all, pill, spirits, and knife. How has this happened to the boy at the start? You lied to me, hurt me, and have broken my heart. I thought I had beaten you time again, but you wanted to kill me. You were here till the end. I pleaded and begged. I got down on my knees. I didn't understand that I had a disease. Take me more than my willpower to keep you at bay. I need support to get through every day. For now, you're dormant, but I know you'll be back unless I do what is suggested and stay on the track. Family and support to keep everything at ease, doing everything I can to arrest this disease. So I'm writing this poem to say my goodbyes. But when I read what you've done to me, I started to cry. Please, if you read this and think alcohol may be your friend, alcohol will kill you. It's there till the end. Adult N died aged 41 on the 17th of June 2020. Adult N was found in his flat after reports of water running down walls. Concierge found the flat flooded from a kitchen sink tap being left on. Adult N was found slapped on his bed, face down on his knees. Emergency services confirmed that all vital signs were inconsistent with life. No formal inquest has been held. The cause of death was acute fatty liver and chronic alcoholism. In the final 2 months of his life, when in Kirklees, no mental capacity assessment was undertaken. One of the agencies involved had limited interaction with adult AIM, namely one telephone contact. Neither this nor discussion with practitioners and other agencies raised concerns about his mental capacity with respect to care and treatment decisions. Principle 1 of the Mental Capacity Act was applied, named that a person is presumed to have capacity unless it is established that they do not. It appears also that telephone contact, the GP, did not have concerns regarding adult N's mental capacity. Mindful again of the first principle, the GP believed that adult was responding appropriately. Health services had reported that some consideration of mental capacity was found in hospital records, but again, the presumption of capacity was influential. NICE Guidance 44 recommends that individuals with a possible need for alcohol treatment services should have an assessment of cognitive functioning, not least because of the possibility of alcohol-related brain damage that can impact on their understanding of the circumstances and the treatment being offered. Adult N, at times, clearly seemed to have appreciated that he needed support. For example, from chart Kirklees Alcohol Services. He was signed person to that service by his GP and by local authority services. His GP was apparently confident that adult N would contact chart, but this may have been perhaps a little bit over-optimistic assessment, given his alcohol dependence and apparent inability to sustain temporary accommodation. However, he did not always act on stated intentions, a bit like the Robert Crane example given at the beginning of this talk. It does not appear that adult N initiated contact with chart. The background also is evidence of several unsuccessful attempts at detox and rehabilitation. The question to consider, therefore, is whether reliance on what adult N said meant an over-optimistic assessment when considered against his actual and repeated behaviour. Was his spoken word, in effect, a cloak of competence, masking an absence of executive functioning? Had prolonged alcohol dependence created an impairment in the functioning of his mind or brain? Was this considered? Was his alcohol dependence evidence of an impulse control disorder? There is no evidence that these questions were considered by any of the professionals involved. This may partly be explained by the lack of knowledge about the involvement of services in Harrogate and Leeds. Had this been appreciated, a more extensive picture of his alcohol dependence would have emerged. And going back to one of the comments made earlier in the talk, lots of focus is given to adult N's ability to articulate. Very little was done to look at adult N's ability to demonstrate his actual coping abilities. One of the questions I do often get asked is, James, but if we do conclude the person's able to make this decision, reality is there is nothing we can do. That, I'm afraid, is just not true. You can, of course, continue to engage with the person, encourage and try to convince them of the benefit of having that support. And this court of protection decision perfectly articulates this point. For the reasons set out above, I am not satisfied on the evidence before the court that the trust has established on the balance of probabilities that C lacks the capacity to decide whether or not to accept treatment by way of dialysis. The judge concluding the patient, in fact, has capacity to make their own decision. The decision C has reached to refuse dialysis can be characterised as an unwise one. That C considers that the prospect of growing old, the fear of living with fewer material possessions, and the fear that she has lost and will not regain her sparkle, outweighs a prognosis that signals continued life will alarm and possibly horrify many. Although I am satisfied that the ongoing discomfort of treatment, the fear of chronic illness and the fear of lifelong treatment and lifelong disability are factors that also weigh heavily in the balance for C. C's decision is certainly one that does not accord with the expectations of many in society. Indeed, others in society may consider C's decision to be unreasonable, illogical, or even immoral within the context of the sanctity accorded to life by society in general. None of this, however, is evidence of a lack of capacity, the court being satisfied that in accordance with the provisions of the Mental Capacity Act, C has capacity to decide whether or not to accept treatment. C is entitled to make her own decision on that question based on the things that are important to her, in keeping with her own personality and system of values, and without conforming to society's expectations of what constitutes the normal decision in this situation, even if such a thing exists. As a capacity individual, C is in respect of her own body and mind, sovereign. So should the doctors just completely disengage? As I said at the conclusion of this hearing, my decision that C has capacity to decide whether or not to accept dialysis does not and should not prevent her treating doctors from continuing to seek to engage with C in an effort to persuade her of the benefits of receiving life-saving treatment in accordance with their duty. Now, although this is a medical treatment case, these are principles that should also be considered by social care professionals. Their duty to C as their patient. My decision does no more than confirm in law C is entitled to refuse treatment offered to her for her benefit by a dedicated treating team. Nothing I have said prevents them from continuing to offer that treatment. Even where we conclude that person is in fact able to make that decision, but the decision they are making is putting them at considerable risk, there is nothing in law that stops us continuing to try and engage with that person. I hope you found this session and talk interesting. There are post-session resources at the end. Much of this talk has been based on the excellent capacity guide, and you will also find some additional resources at the end. So all of the resources that I have referenced and mentioned, you can find at the end of the presentation. These are all working hyperlinks. If any of you are interested in more formal training, my contact details are at the end. My name is James Codling, work for Cambridgeshire County Council, and I am their Mental Capacity and Deprivation of Liberty Learning and Development Manager. I hope you have found this talk interesting, and that is now the end of the session. Thank you all very much.